Hello friends, hope you are doing great. Welcome to set 2 of Gujrat Judicial Services Preliminary Examination Analysis of the Question Paper powered by LawSikho. In this set, we are going to take up questions of legal and English knowledge from question number 33 onwards. The target audience again that this course is going to help includes students of law, lawyers and advocates who have appeared or intend to appear for the various competitive exams such as judicial services of various states, particularly Gujarat, other competitive exams where multiple choice questions on legal knowledge are asked, and anyone who wishes to remain updated with the current trend of judicial services examinations through past year papers. So let's get started with question number 33. Mind you again that we are going to take a note of the legal as well as English knowledge questions that have been included in this particular question paper. So far as the general knowledge questions are concerned, separate videos would be made on the same. So let's get started. The question here states, the court of a magistrate of the first class may pass a sentence of imprisonment for a term not exceeding dash years. A 2, B 7, C 3 and D 5. The answer to this question is option C, that is 3. The answer is found in section 29 clause 2, which provides that a court of a magistrate of the first class may pass a sentence of imprisonment for a term not exceeding 3 years or fine not exceeding 5,000 rupees or both. The level of this question is easy as it is targeted as one of the very frequently asked questions from the Criminal Procedure Code. Coming to question 34, which states, inadequacy of consideration is relevant in determining the question of A. Fraud, B. Undue influence, C. Misrepresentation, and D. Free consent. The answer to this question is option D, that is free consent. Now, explanation 2 of section 25 of the Indian Contract Act states that an agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate. But the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promisor was freely given or not. Let's consider an example in regard to the same. A house which is valued at rupees 1 crore as per its market value is sold to someone for rupees 10 lakhs. Now the consideration here is definitely inadequate, but it would not be considered as unreal consideration. It would only become a matter of concern if it can be seen or gauged that such consideration or such promise of giving the house for rupees 10 lakh was not freely given. The level of this question is tough. It requires thorough knowledge of the Bare Act, and those options are very close, and that is why it becomes difficult to analyze what exactly the answer could have been. Question 35. X works in the office of Y, who is a chartered accountant. Y hands over cash worth 1 lakh to X for being kept. X spends the said amount for the purchase of furniture in his house. X has committed an offense of A. Dishonest misappropriation of property, B. Mischief, C. Cheating, and D. Criminal breach of trust. The answer to this question is option D, that is criminal breach of trust. Now, section 405 of the Indian Penal Code defines criminal breach of trust as whoever, being in any manner entrusted with property or with any dominion over property, dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person to do so, commits criminal breach of trust. The level of this question is medium as it requires the interpretation of a section of the Bare Act. The illustrations given as regards section 405 of the Indian Penal Code are very similar to this fact situation. Still, reaching a conclusion becomes slightly difficult, and that is why the level of this question has been termed as medium. Question 38 is from the Indian Contract Act. It states a wagering contract is void under A. Section 28 of the Indian Contract Act, B. Section 29 of the Indian Contract Act, C. Section 30 of the Indian Contract Act, and D. Section 31 of the Indian Contract Act. The answer to this question is option C, that is Section 30 of the Indian Contract Act. Now, Section 30 of the Indian Contract Act, the heading itself states agreement by way of wager to be void. The level of this question is easy. It has been directly picked up from the heading of a particular section and is also very frequently asked so far as the topic of Indian Contract Act is concerned. Moving forward to question number 41, the middle two questions, that is 39 and 40, were from general knowledge, and that is why we are jumping over to question number 41. Question 41 states acceptance to be valid must be A. Unqualified, B. Absolute and unqualified, C. Conditional, and D. Absolute. The answer to this question is option B, that is absolute and unqualified. The answer is found in section 7, which states acceptance must be absolute in order to convert a proposal into a promise. The acceptance must be absolute as well as unqualified. The level of this question is medium. It requires knowledge of the WARE Act and is again a very frequently asked question, as section 7 is a very important topic from the Indian Contract Act. Question 42. Which of the following is the fundamental duty of every citizen of India? A. To be truthful to one's duties. B. To renounce practices derogatory to the dignity of children. C. To renounce practices derogatory to the dignity of human beings. And D. To renounce practices derogatory to the dignity of women. The answer to this question is option D, that is to renounce practices derogatory to the dignity of women. Now, Article 51A, Clause E states to pronounce harmony and spirit of common brotherhood amongst all people of India, transcending religious, linguistic, and regional or sectional diversities, and to renounce practices which are derogatory to the dignity of women. Friends, we have seen in our history that practices such as dowry, female infanticide, sati, etc. have been very deeply entrenched in our society. And that is why to make practices, to renounce practices derogatory to the dignity of women became very important to be included in one of our fundamental duties. The level of this question is medium. It requires good knowledge of the WARE Act. Fundamental duties is one of the most important topics from the Constitution of India, both for prelims as well as mains, and that is why one must definitely have good knowledge of the same. Question 43 states, when dash persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means, such an agreement is designated as criminal conspiracy. A. Several. B. 3 or more. C. 2 or more. And D. 7. The answer to this question is option C, that is 2 or more. Now, section 120A of the Indian Penal Code defines criminal conspiracy as when 2 or more persons agree to do or cause to be done 1. An illegal act, or 2. An act which is not illegal by illegal means. Such an agreement is designated as criminal conspiracy. The level of this question is easy as it is a very frequently asked question. Question 44 states, when can the provision of section 210 of the Criminal Procedure Code be invoked? A. When there is a complaint case but police is not investigating the matter. B. All of these. C. When there is a complaint case and police is also investigating the matter. And D. When there is a complaint case and police has already completed investigation and submitted a final report. The answer to this question is option C, that is when there is a complaint case and police is also investigating the matter. Now, section 210 of CRPC states procedure to be followed when there is a complaint case and police investigation in respect of the same offense. The level of this question is medium as thorough knowledge of the WARE Act is required in such a scenario. Question 46. causing disappearance of evidence of offence or giving false information to screen offender is punishable under section dash of the Indian Penal Code. A 201, B 203, C 202 and D 204. The answer to this question is option A, that is 201. We would rate the level of this question to be medium as good knowledge of the sections of the BEAR Act is required. Question number 47. We can see that the middle two questions are again from general knowledge, and hence we straight away jump to question number 47. It states, what is the period of limitation for filing an application for setting aside an abatement? A 60 days, B 90 days, C 30 days and D 1 month. The answer to this question is option A, that is 60 days. Now, Article 121 of the Limitation Act states, under the code for an order to be set aside by an abatement, the time limit that has been given is 60 days from the date of abatement. The level of this question is tough as it is a memory-based question and requires a thorough knowledge of the BEAR Act. Question number 48 is a question from the English language. It states, Ram, the prince of Ayodhya, dash his siblings. A. Vitiated, B. Endangered, C. Adorned, and D. Adored. The answer to this question is option D, that is adored. Now the term vitiate literally means to annul or to cancel something. So it does not apply with respect to people, and hence we know that this cannot be an answer. Option B talks about endangered, which means to put someone at the risk of danger. Now, factually speaking, we know that Prince Ram did not per se wanted to endanger his siblings or his brothers and sisters. Adorn means to make someone beautiful or attractive. This does not come out to be the motive from the given sentence. And finally, the term adore means to love someone unconditionally, which definitely is the answer and hence correct in this scenario. The level of this question is medium, as one must definitely know the meanings of these words to be able to give the answer correctly. Plus, the term adorn and adore can be slightly confusing here. Question number 49. Under sections 141 of the Indian Penal Code, an assembly of dash or more persons is designated as unlawful assembly. A7, B3, C2 and D5. The answer to this question is option D, that is 5. The level of this question is medium. It requires a knowledge and understanding of the BEAR Act of the Indian Penal Code. Moving forward to question number 51, it states, no suit shall be instituted against the government or against a public officer in respect of any act purporting to be done by such public officer in his official capacity until the expiration of dash after notice in writing has been delivered. A. 2 months, B. 3 months, C. 60 days, and D. 1 month. The answer to this question is option A, that is 2 months. Now, this question has been picked up from the Civil Procedure Code, particularly Section 80, which provides that no suit shall be instituted against the government or against a public officer in respect of any act purporting to be done by such public officer in his official capacity until the expiration of 2 months next after notice in writing has been delivered. I would rate the level of this question to be tough as it requires a thorough knowledge of the sections of the BEAR Act of Civil Procedure Code, which is otherwise very lengthy in nature. Coming to question number 52, which is from the Indian Contract Act, it states, in a valid contract, which of the following comes first? A. Promise, B. Proposal, C. Enforceability, and D. Acceptance. The answer to this question is option B, that is proposal. The proposal is defined under Section 2A of the Indian Contract Act. It says, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of the other to such act or abstinence, he is said to make a proposal. The level of this question is medium as it requires the interpretation of the section to answer the particular question. Question number 53 is from English language again. It says, What is the sacrosanct? What is the synonym for sacrosanct? Now the term synonym means something which means the same. Option A is most sacred, option B is cheerful, option C is mournful, and option D is sarcastic. The answer to this question is option A, that is most sacred. That is the closest option, which means sacrosanct is most sacred or most revered. Question number 54 is from the Indian Contract Act. It states an agreement in restraint of trade is A, valid, B, voidable, C, void, and D, unenforceable. The answer to this question is option C, that is void. Section 27 particularly here states an agreement in restraint of trade is void. The level of this question is easy as it has not only been directly picked up from the heading of a section of the BEAR Act, but is also a very frequently asked question. Question number 55 is from the Negotiable Instruments Act. It states, for the purpose of attracting the provisions of Section 138 of the Negotiable Instruments Act, a check has to be presented to the bank, A, within a period of 3 months from the date on which it is drawn, or within a period of its validity, whichever is earlier, B, within a period of 6 months, C, within a period of 6 months from the date on which it is drawn, or within a period of its validity, whichever is earlier, and finally option D, within a period of 15 days from the date on which it is drawn. The answer to this question is option C, that is within a period of 6 months from the date on which it is drawn, or within a period of its validity, whichever is earlier. Now, Section 138 of the Negotiable Instruments Act is a very important section. It deals with dishonor of check for insufficiency, etc., of funds in the account. The proviso to this section states the check has been presented to the bank within a period of 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. Thus, we can see that this question has directly been picked up from the proviso of Section 138. The level of this question can be marked as tough as it requires thorough knowledge of the provisions of the PAIR Act. Even though Section 138 is one of the very important sections of the Negotiable Instruments Act, still knowing the intricacies of its proviso becomes slightly tough. Question 57. When commission is to be issued for examination of a witness who is within the territory to which the Code of Criminal Procedure applies, to whom shall such commission be directed? A, the district magistrate within whose jurisdiction the witness is to be found. B, the chief judicial magistrate within whose jurisdiction the witness is to be found. C, the executive magistrate within whose jurisdiction the witness is to be found. And D, the district judge within whose jurisdiction the witness is to be found. The answer to this question is option B, that is the chief judicial magistrate whose jurisdiction the witness is to be found. This answer is found in section 285 of the Criminal Procedure Code. It says commission to be issued. If the witness is within the territories to which the code extends, the commission shall be directed to the chief metropolitan magistrate or the chief judicial magistrate, as the case may be, within whose local jurisdiction the witness is to be found. The level of this question is medium as it requires good knowledge of the BEAR Act. Question number 58 states, within what time a party who has obtained an order for leave to amend the pleadings is required to carry out the necessary amendment when no time is limited by the order? A, 14 days, B, 15 days, C, 30 days, and D, 45 days. The answer to this question is option A, that is 14 days. This answer is found in Order 6, Rule 18 of the Civil Procedure Code 1908, which casts a duty on the party to carry out amendment, if allowed by the court within the time limited for the said purpose by the order, and if no time is thereby stated, then within 14 days from the date of the order. The level of this question is medium as it requires a knowledge of the BEAR Act and is a frequently asked question. We come to question number 60 now, which states Article 14 of the Constitution of India guarantees equality before law and equal protection of law to A. All citizens of India living in India, B. All persons, natural as well as artificial, C. All persons living within the territory of India, and D. All persons domiciled in India. The answer to this question is option B, that is all persons, natural as well as artificial. The answer is found in Article 14 of the Constitution, which states that the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. Friends, we know that the fundamental rights, some of them are such which are applicable only to the citizens, while other fundamental rights are applicable to all persons. And Article 14 is a case of the latter. The level of this question is medium as it requires the interpretation of the section, and the options can be slightly confusing here. Coming on to question number 62, leaving the two general knowledge questions in the middle, question 62 states, in case of an offense punishable with fine only, the offender who is sentenced to pay a fine exceeding rupees 100, the imprisonment in default of payment of fine shall not exceed A. 1 year, B. 4 months, C. 6 months, and D. 2 months. The answer to this question is option C, that is 6 months. This answer is found in section 67 of the Criminal Procedure Code. It talks about imprisonment for non-payment of fine when offense punishable with fine only. If the offense be punishable with fine only, the imprisonment which the court imposes in default of payment of fine shall be simple, and the term for which the court directs the offender to be imprisoned in default of payment of fine shall not exceed the following scale. That is to say, for any term not exceeding 2 months, when the amount of fine shall not exceed 50 rupees, and for any term not exceeding 4 months, when the amount of fine shall not exceed 100 rupees, and for any term not exceeding 6 months in any other case. Friends, the level of this question is very tough, despite the fact that section 67 is one of the frequently asked sections, as it requires the interpretation of a particular section. Question number 63. What is the period for which a person can be detained in civil prison if execution of a decree is for the payment of sum of money exceeding rupees 1,000? The answer to this question, exceeding rupees 5,000. The answer options to this question are A. Not exceeding 6 weeks, B. Not exceeding 1 month, C. Not exceeding 2 months, and D. Not exceeding 3 months. The answer to this question is option D, that is not exceeding 3 months. Now, section 58 deals with detention and release. It states every person detailed in the civil prison in execution of a decree shall be so detained: A. Where the decree is for the payment of a sum of money exceeding rupees 5,000 for a period not exceeding 3 months. The level of this question is medium as it requires a good knowledge of the Bare Act. Coming on to question number 65, which is again from English vocabulary. The term here has been given is obscure, and one has to choose the opposite of it. Options are A. Pedantic, B. Implicit, C. Obnoxious, and D. Explicit. The answer is option D, that is explicit. Obscure means something which is hidden or not discovered or not known about. So the opposite of it would be explicit, that is something which is out there and of which everyone knows of. The level of this question can be termed as tough as it requires knowledge of the word along with the knowledge of the meanings mentioned in the options. So friends, so far as this set is concerned, this was the end of the video. In the next set, we'll take up question number 66 onwards. I hope you're enjoying these video series. Please do stay tuned for more. Thank you.